A very good evening to you, ladies and gentlemen. I am excited to welcome you to this Bar Association of Sri Lanka webinar organized by the professional. A very good evening to you, ladies and gentlemen. I am excited to welcome you to this Bar Association of Sri Lanka webinar organized by the Professional and Career Development of Women Lawyers Committee of the Bar Association, supported by the Bar Association Seminars Committee on the topic Options for Dispute Resolution. This is the 9th webinar of the 4th webinar series on professional, personal, and career development hosted by the Bar Association of Sri Lanka and conducted on the Zoom platform. And for those of you who are unable to register on Zoom, hopefully you're joining us on the YouTube live stream on the BASL YouTube channel. Before we start, we would like to thank the Professional and Career Development of Women Lawyers Committee of the Bar Association, the chairperson, Mrs. Indika Nagaratna Kodakota, co-chairperson, Mrs. Nalini Manatunga, convener, Mrs. Aparajita Aryadasa, and co-conveners, Mrs. Umeshika Dalpadatu and Mrs. Vindika Subasingha. We would also like to thank the Seminars Committee of the Bar Association, the chairperson of the Seminars Committee and secretary of the Bar Association, Mr. Rajiv Amrasurya, convener of the Seminars Committee and assistant secretary of the Bar Association, Mr. Pasu Silva, and the co-conveners, Mr. Pandula Vanniyarachi, Mr. Oshan Uberatna, Mrs. Anne Devendra, and Mrs. Nikini Mapitigama. I would also like to take this opportunity to thank the President of the Bar Association, Mr. Salia Pires, President's Council, and the other members of the Management Committee of the Bar Association for all the support and guidance. As mentioned, today's topic is on options for dispute resolution, and it gives me great pleasure to introduce the esteemed panel and moderator for today. Firstly, let me introduce His Lordship, Honorable Justice Yasantha Kodagoda, President's Counsel. Justice Kodagoda was called to the bar on the 28th of October, 1988. He holds a postgraduate diploma in forensic medicine and sciences from the University of Colombo and a Master of Laws degree in public international law with merit from the University College, London. On the 1st of February, 1989, he joined the Attorney General's Department as a State Counsel and was promoted as a Senior State Counsel in 1999, a Deputy Solicitor General in 2005, and an Additional Solicitor General in 2015. On the 18th of March 2015, he was awarded Silk as a President's Counsel. Justice Kodagoda was appointed as the President of the Court of Appeal on the 28th of March 2018 and was thereafter appointed as a Justice of the Supreme Court on the 3rd of February 2020. Our second esteemed member of the panel is Mr. Harsha Fernando. Mr. Fernando is an attorney at law with over 25 years of experience. As a specialist in commercial negotiation and mediation, he provides negotiation and mediation services and advice to both local and foreign clients. Currently, he's an international consultant to the Office of the General Counsel of the Asian Development Bank. He's a visiting lecturer. He's a visiting resource person, rather, to several institutions, including the prestigious Queen Mary University of London and the Postgraduate Institute of Management of the University of Sri Jayawardenepura. Prior to starting his own chamber, he was a Senior State Counsel at the Attorney General's Department. He read law at the Sri Lanka Law College and holds an MBA from Singapore and the Massachusetts Institute of Technology, USA. And he also holds a Master of Laws degree from King's College, London. He's a Chevening Scholar, Nanyang Fellow of Singapore, and had secured the Most Outstanding Young Person of the Year award for legal administration in 2011 from the Junior Chamber International. Final member of the panel is Mrs. Dulanga Pereira Weideman. Mrs. Weideman was called to the bar in the year 2000 and counts over 20 years of legal experience, both in public and corporate sectors, having served for over 12 years in a senior managerial capacity. She is currently the Group Chief Legal Officer of Global Rubber Industries Private Limited. Previously, Mrs. Weidemann was the General Manager, Legal and Corporate Secretarial Services of Hemas Holdings PLC. Prior to her employment at Hemas, Mrs. Weidemann served as the head of legal of the brewery sector of Carson's group of companies for a period of over 6 years. Mrs. Weidemann holds a Bachelor of Arts degree from the University of California and a Master of Laws degree from the University of Colombo. The moderator for this session is Mrs. Natasha Noordin. Mrs. Noordin was called to the bar in the year 2015. She had provided both litigation and transactional services, mainly in commercial, contract, and construction law. She has also worked as a consultant to the European delegation of Sri Lanka, and during her brief stint, supported in crafting development programs for both Sri Lanka and Maldives. She has worked on issues relating to public procurement, right to information, business and human rights, and country assessment on WTO commitments of Sri Lanka. She holds a Bachelor of Laws degree from the University of London and was a visiting lecturer at a private educational institution in Colombo that awards UK-affiliated undergraduate degrees in law. Finally, members joining this session by Zoom may send in their questions through the Q&A chat box to reach the moderator. I would now like to hand over the proceedings to the moderator. Over to you, Mrs. Noordin.
Thank you very much for that very generous introduction, Tanuja. Good evening, ladies and gentlemen, and good evening to the distinguished panelists. The main topic of discussion for today and the main objective of this discussion is to provide you with perspectives and insights on the options for dispute resolution in Sri Lanka. So for that purpose, we have divided this discussion into 3 rounds. The first round, providing you, the audience, with the introduction to the types of ADR options available in Sri Lanka. We would then move on to the second round, where the main aim is to provide insights into the appropriateness of ADR and the practical use of ADR mechanisms when providing effective resolutions for disputes. The third and final round would comprise of a question and answer session, which would enable you as the audience to engage with the panelists on specific areas of interest. At this point, again, I would also like to invite you, the audience, to submit your questions. In that Q&A box, as referred by Tanuja, it's right under your screen at the bottom. If you press, if you can't see it, there will be a more little with 3 dots, which would have chat and questionnaire. You can drop any answers that you want to me that you would like to ask the panelists. On that note, I would like to start off the first round by inviting our first panelist, Mr. Harsha Fernando, who's both a litigator as well as a conflict management specialist, who has vast experience and knowledge in dispute resolution, to speak on the topic of the types of ADR or types of dispute resolution options available in Sri Lanka. Good evening, Mr. Fernando.
Thank you, Natasha, and thank you, Tanuja, for that introduction, and good evening, everybody. I'm very happy to be on this panel chaired by Justice Kasantha Kodakada, who at one time was my senior in the Regis department, and then 2 colleagues. So I will straight away get to the topic in hand. I have prepared a short presentation. May I share that with you now? Natasha, could you please confirm whether you can see my screen?
Yes, I can see your screen.
Thank you. So I think when the organizers invited me to speak on this topic, I asked them why, because we did a webinar on a similar topic through the Bar Association webinar series under different category. So apparently what I was told was it has generated a lot of interests. And then they wanted to bring this within the skills emphasis that the Bar Association is bringing through this seminar series. I think that's a very, very positive direction that is being taken to know that colleagues at the bar are beginning to look at disputes slightly differently. And there is an interest in looking at what are the other ways of dealing with them without necessarily looking at courts as the only solution for our issues. If you notice, the topic I have slightly changed from what you received. What you probably got was on dispute resolution. I don't necessarily like the word resolution, simply because I believe that many disputes cannot be resolved. What we can do is to manage those disputes to give a positive outcome to the disputants. And to that extent, we need to see the dispute differently. We need to see our role differently as attorneys at law, and also see the way we approach an issue slightly differently. Now, disputes can arise on anything, whether it's a personal agreement between friends, an agreement in your private life, like even a divorce, marriage, divorce, which are all agreements, or it can be in the commercial sense of a contract. So I'm going to take the contract as an example to illustrate a key point to you. And that is, never ever forget that when we get involved as lawyers, not because people want us to get involved, but because people have no choice. At least that's how they see it. So they want us to get involved because an underlying arrangement that they made has gone wrong. By the time they come to us with, quote unquote, a dispute, an arrangement has already taken place. And that arrangement took place on the assumption that the one or two or more parties to that arrangement felt that they could go, that they can get more, that they can obtain more value by going jointly into something than doing it alone. So even a commercial contract is the same thing. Two business entities feel that if they combine their resources together, the return and the reward is far greater than doing it alone. Most of the time, when we deal with a dispute, we tend to forget that fundamental. And that is one of the reasons why, as lawyers, we sometimes get a bad name as people who are living off miseries of others, or trying to add to the already suffering parties. It's simply because sometimes we tend to forget the underlying arrangement. And I will demonstrate perhaps in my second part of the presentation that it is not necessarily our fault, but it is because of the system in which we operate and, of course, the way we see things. Now, once you had got that into, you internalize that concept that our services are required because a good arrangement, something went wrong in it. That's why our services are required in a civil sense. Then the disputes that arise out of that arrangement also needs to be considered in the same light. Most of the time, we sort of tend to divorce it. We're saying, okay, that arrangement, well, that's your business deal. Let me handle the law part. Well, yeah, law per se, yes. But the whole process of helping your clients to manage with that dispute, you need to, I think, be a little more enlightened in your approach. Sometimes, because of our professional dictates, which we have interpreted in particular ways, or because of our limited vision, if I may say, sometimes I would even use the word to some extent myopic. We might not want to see the broader implications, but then, from the word go, try to get into it as a dispute, a fighter, a gladiator, a battle, which is in the ultimate analysis, bad for our clients, bad for us, bad for the system of which we make a living, and it's a sort of a lose, and it's lose for everyone around. So the point that I want to make very, very emphatically at the beginning of this presentation is to understand these two key things. One, there is a value creating arrangement already made. We had nothing to do with it. if we had anything to do with it, we probably would not have got made. But there is a value creation arrangement that has already been made. And for some reason, maybe good faith, bad faith, we don't know. For some reason, something has gone wrong in it. And the parties to that arrangement are unable to deal with that on their own. So they need a third party help. And that's where we get involved. So if we see it that way, then we see our role also differently. Right? We see our role also differently. For the longest of time, my late father never really was happy that I became a lawyer because he wanted me to become a doctor. Because he always said that in an emergency, nobody calls for a lawyer, but everybody calls for a doctor. I don't know whether that had any influence on me, but over a period of time, I like to call myself and all my colleagues at the BASL conflict doctors or conflict managers, because if you really think about the key value addition that we can bring to conflict, I mean, we are in the conflict management business. We hold a monopoly in conflict management business. The value addition that we bring is simply that we have to help people to manage their disputes to get them good outcomes. So to that, we need to get away from this sort of lawyer thing, become conflict doctors, conflict managers, capable of doing diagnosis and advising them what needs to be done. We have to be part of the value creators. There's an additional R there, sorry about it. We have to be part of a value creators. And then we have to be strategic in aligning people's interest so that they will behave in a particular way that brings forth the maximum in that value creation. Okay, so basically I said what is the dispute. I will stop with this slide. You see, this is a slide which hopefully bring the whole our options available to us to deal with disputes. Now these are the different strategies that are available to us to deal with a dispute. When a dispute arises, I will take a simple example of a fight between a husband and a wife or a couple. When the conflict starts, the first thing you do is you sort of tend to forget it, hoping it will go away. That's the avoidance strategy. You know, you're working all the time, you're neglecting your significant other, and the person is not happy, but you sort of avoid it, hoping it will go away. When you realize that that's not going away, then we tend to do a little bit of informal discussion. Hey, what's wrong? What's going on? When that doesn't work, then we get into a formal negotiation and say, look, we have a problem, we need to discuss. Now, there also, if we can't come to an acceptable situation, then we find that old uncle who introduced us in the first place and tell him to mediate between the two of us and try to figure out what's going on. If you look at it, all those things happen between us in the private sphere. Nobody knows about it. But moment that doesn't work, then we need to go to an external third party and we tell that party, look, make a decision on our behalf. And that's where you go for arbitration or an administrative decision. Now, if we don't want to use that option, then we go to a completely public area, like a divorce court, where we go into the judicial decision process. Now, if all those systems have failed, then we go into the extra legal decision process where you have non-violent action or violence. Example, you would rather pay a thug and get your tenant to leave the house than go through a lengthy litigation process. That's where you feel that the cost-benefit analysts are doing that is much better than going through the process. But what I want to emphasize to you is these are the different types of methods available to you to deal with different disputes. Now, our problem is sometimes the dispute, can you see my cursor moving here? Sometimes the dispute that should get sorted here, because we don't have the skill set or the attitude to sort it out here, gets decided either here or here. Now that, unfortunately, adds a lot of tension, cost to the system and to the parties. The classic example is, my practice is predominantly before the appellate courts and mostly in the Supreme Court. I'm amazed at the number of cases that get settled in the Supreme Court. I simply ask the question, couldn't these two lawyers sort it out in the district court without spending so much of time and cost until a judge of the Supreme Court shows them the stupidity of what they have done? Sorry for using that word, but basically showing them, look, if you take a little more enlightenment, you're going to sort this out. That I say is a failure in us as lawyers, that we were unable to see that possibility at an appropriate time. So I'm going to stop for the moment, and I will continue as to why some of these choices are better than the others at the next round. As a final thought, I would also say that I don't necessarily like the word ADR. I know a lot of people use the word alternative dispute resolution to mean alternative to the court system. I would rather see it as another one in a continuum. It's just that it has different dynamics. So if you are a conflict doctor, you should advise your client, look, the nature of your contract is this, nature of your agreement is this, these are the possible types of disputes that can arise. The ideal way to deal with those disputes is this method instead of the other method. Now that's second benefit I would see in using this arrangement as in the slide. This is not mine. This is adopted from a textbook on mediation. Over to you, Natasha.
Thank you, Mr. Fernando, for providing us with that foundational knowledge. I would now like to welcome our second panelist, His Lordship, Justice Yasantha Godagura, who is currently presiding as a judge of the Supreme Court of Sri Lanka. Sir, given your keen interest and invaluable knowledge on the subject matter, specifically on using dispute resolution tools such as mediation, I would like you to provide your thoughts and insights into the options of ADR in Sri Lanka. Good evening, sir.
Good evening, and thank you very much, Natasha. Good evening, ladies and gentlemen. I would like to approach this topic in the following manner. In our day-to-day lives, in our personal capacity, as well as in our vocations, professions, business activity, etc., we encounter two very negative and extremely harmful at times phenomena. They are disputes and conflicts. Disputes and conflicts. A dispute is not a complicated issue. A dispute is a disagreement. So at the very core of a dispute is a disagreement where two or more people don't agree on a specific issue. So a dispute is a disagreement between two or more parties regarding one or more specific issues. This happens all the time. This happens all the time in both our official spheres as well as in our personal lives. And I think it is very human. People have different interests. People have different points of view. People have different attitudes, values, the baggage they carry from the past, etc. So disputes, disagreements is certainly a very human phenomena. And I would think that life would become extremely artificial if everybody with whom we interact day in, day out starts agreeing on everything. So disputes are very natural, inevitable in very nature, associated with and possibly arising out of a dispute or multiple disputes is a more aggravated, further negative, even more harmful, consequential phenomena referred to as conflicts. Disputes, if they are not redressed or resolved in a timely manner, in an appropriate manner, tends to get aggravated into a conflict, and people start fighting with each other, people stop talking with each other, people lose cohesiveness and harmony. It's very disruptive and extremely harmful. And when two or more people are in conflict, either as individuals or as groups of persons, further disputes are bound to happen. When you're angry with somebody, you obviously don't like to agree with him, even on very mundane issues in respect of which agreement can be easily reached. So conflicts are very harmful. We need to avoid conflicts because of the negative consequences. And throughout human civilization, right from the very beginning, people have developed various options, I would say / reactions to both disputes and conflicts. There is a vast menu of options that people have developed. And as Mr. Fernando said, at one end is not responding at all. Mr. Fernando said it's a form of denial. Indeed, it can be a form of denial. It can also be a means of accepting defeat and fleeing away from the theater, having accepted it. So that's at one end. Generally, when the dispute is so trivial in nature, when the interpersonal relationship between the two disputants is more important than the dispute proper, people tend to avoid responding at all. Or when they perceive defeat right from the beginning, they also decide not to respond at all. So that's at one end. At the other end is an extremely harmful, yet practically feasible option, and that is fighting. It can involve only a verbal interaction, like in the case of an argument. It can even involve violence, physical violence, mental trauma, and it is extremely injurious to the relationship. Yet, fighting remains to be a very efficacious option in the menu of dispute resolution mechanisms, and we have seen that even in our own country. Now, in between fighting and fleeing or defeat, not responding at all, there is a menu of options that human civilization has developed. They all involve communication, talking or writing, flow of information both ways. Our topic here relates to those communication-centered dispute resolution mechanisms. And in the entire menu of communication-centered dispute resolution mechanisms, or ADR, or dispute management mechanisms, as Mr. Fernando said, are the following: negotiations, mediation, conciliation, contractual adjudication, arbitration, and judicial adjudication. Judicial adjudication is the mechanism that we invoke whenever we file a case. So through litigation, you file a case and engage in litigation. And we as lawyers, we do that on behalf of our clients. We seek the resolution of the dispute that we present to court through a highly technical, legalistic mechanism referred to as judicial adjudication. Now, as lawyers, either because of sheer ignorance or due to our litigation-associated tendencies and our professional culture, whenever a litigant comes to us with a dispute, it can be a financial dispute, a land dispute, a family dispute, a dispute with the state, such as in the case of an infringement of a fundamental right, a grievance arising out of a decision taken by a state authority, so on and so forth. Whatever the dispute is, the tendency, and I would think the unfortunate tendency that a large percentage of lawyers have, is to look at only litigation and through that adjudication as the means of resolving our clients' dispute. We virtually jump to that mechanism without for a moment wondering whether negotiation, mediation, conciliation, contractual adjudication, or arbitration would be more appropriate for the resolution of our client's dispute. Why is it that we spend time discussing about these mechanisms? For several reasons. One being that if you really look at the outcome of a court case, a judgment or a judicial order, yes, there is a party that wins, but there is a party that loses as well. And possibly your client might be the party that loses the case. So he goes in with the intention of winning, he comes out losing the battle. So the outcome being beyond the control of the litigant, the outcome of the process being beyond the control of the litigant is one negative feature of litigation / judicial adjudication. Parties don't have much control over the process as well as the outcome of litigation. It's highly technical. As judges, our discipline and our training is to resolve the dispute in terms of the law. I will repeat that, to resolve the dispute in terms of the law. We are conscious that sometimes resolving the dispute in terms of the law does not redress the entire dispute, does not redress the root causes for the dispute or the underlying issues. So it might not be a victory even to the party which wins the case. That is very unfortunate. Then, of course, inordinate delay, most of which is unavoidable to the sheer volume of work in court, and of course, the expense. Colloquially, it is said that only lawyers win through cases and not clients. So these are the negative features of litigation / adjudication. And therefore, I think as professionals, as legal professionals, we must look at these other mechanisms that are available, such as negotiation, mediation, conciliation, contractual adjudication, arbitration, as possible alternative mechanisms. Now, having said that, I must say, particularly in the sphere of transactions that are regulated by formal agreements or contracts, written contracts in particular, the means of dispute resolution is often pre-decided during the formation of the agreement. And it is codified, it is put down in writing in a very important clause in a written contract, referred to as the dispute resolution clause. So if, for example, parties are thinking of contractual adjudication or arbitration as means of dispute resolution, for all practical purposes, it would have to be so stated in the dispute resolution clause of the agreement. I wouldn't want to take more time because there are other panelists and we are going to have another round as well. I will come back and maybe spend some time with you on some of these mechanisms in greater detail when we meet during the second round. Over to you, Natasha.
Thank you, sir, for providing us with your insights. I would now like to welcome our final panelist, Dulanga Vaidyaman, who has a vast and refined experience in the corporate world, negotiating and resolving issues on a daily basis. Please provide us with your insights as to what types of tools you use as a corporate lawyer in order to approach commercial disputes or issues rather than calling it disputes sometimes. Over to you. Good evening, Dulanga.
Good evening, Natasha. Thank you. Considering the content of the two learned speakers before me, my presentation will be from a different perspective, a corporate perspective in relation to the use of alternate dispute resolution mechanisms in their commercial contracts. So what I would like to do in this segment is, as Natasha suggested, talk through some of my experiences as a corporate counsel in advocating to the companies that I have worked for more suitable and appropriate dispute resolution mechanisms for their business contracts. As a corporate counsel, most of the time, we are tasked with either negotiating or drafting a contract or reviewing a contract, which has been shared by a counterparty. Whilst when negotiating and drafting a contract, we have the option of proposing a suitable dispute resolution mechanism. When reviewing a contract, most often we are confronted with a dispute resolution clause that has already been inserted or proposed in the contract. Either way, we are then tasked with advising our client, who is the company, whether the proposed mechanism is the most suitable avenue in the context of the business transaction that is being entered into. There are several considerations that need to be taken into account when recommending to or advising the company of the most appropriate dispute resolution mechanism. Primarily, as I said earlier, one should consider the nature of the contract entered into. If the contract is highly technical in nature, such as a software agreement or a construction contract or even a technology transfer contract, we tend to propose arbitration as a means of dispute resolution, since that would mean having an adjudicator who has the expertise and the experience in that specific field to effectively deal with the dispute. But if the contract is a goods and service supply contract or a distribution contract, where the transaction is a straightforward supply versus payment transaction, then as a corporate counsel, you would advocate for a litigation option on the basis that litigation is the most suitable option to recover a claim that is due to you over the contract. But before you do so, bearing in mind, as Justice Godagoda also pointed out, and Mr. Fernando also pointed out, bearing in mind the delays in pursuing the litigation option, you may want to take into account other considerations in this type of contracts. That would be the relationship of the parties and also the duration of the business partnerships that the parties would have had. If you're aware that the parties have been in a long business relationship, you would recommend a mechanism such as mediation to precede litigation. Sometimes, as a step even prior to mediation, you could suggest discussions and negotiations between the principal officers of the parties as a means of settling the dispute or preventing the escalation of the dispute. Another example of where you would strictly consider the relationship of the parties before including a traditional dispute resolution mechanism, such as litigation in the contract, is if you're dealing with a shareholder agreement. In certain instances, it may very well be that the company has contracted with well-known people or corporates or with known associates in the same business circles. then you would want to advise the company of the importance of including negotiations or mediations as a pre-step to the traditional litigation option or to even the arbitration option. You would point out that this would facilitate the parties to analyze the root cause of the dispute at an early stage and find a resolution that would not compromise the party's reputation or the business relationship, or sometimes even risk confidential information getting out. So when talking of considerations, when recommending dispute resolution mechanisms in cross-border or international contracts, the consideration may be a little different. Of course, when you are a Sri Lankan company and dealing with a European country or a company in the US, it's all the more difficult to negotiate a dispute resolution clause where the jurisdiction for the dispute resolution is either in Sri Lanka or even in the Asian region. Some parties agree, but some big companies are quite steadfast in their decision that the jurisdiction should remain in their respective jurisdictions. In these instances, the more advisable approach would be to first negotiate really hard on the contract and try to limit your liabilities in terms of quantum and duration. And secondly, to negotiate to include a mediation clause that would help sort out the matter before resorting to the ultimate dispute resolution mechanism that was proposed in the first place. But in recommending a dispute, if you're recommending a dispute resolution clause for international contracts, the preferred option would always be arbitration, primarily because of the cost factor. Because we may not be familiar with the laws in those jurisdictions, and if we are to agree to litigation, we will be faced with the issue of retaining a counsel from that particular jurisdiction or a law firm, and then the cost involved would not justify that decision. But that is not to say that arbitration is not costly, because it is, especially depending on the seat of arbitration. And again, we have the issue of retaining counsel for those jurisdictions. And as corporates, we also need to consider the cost of travel and accommodation for the company representatives during the term of the hearing. So all those considerations have to come into play. Therefore, when recommending alternate dispute resolution mechanisms to the company, whether it be a local contract or an international contract, considering the final exposure that the company would, the financial exposure that the company would be faced with by a potential dispute, as a corporate counsel, it would serve us well if we could propose alternate dispute resolution mechanisms that would suggest to strengthen the relationship between the parties so that the parties themselves can mutually agree to resolve disputes without resorting to costly resolution mechanisms. Without, so that to do it without expending too much money or time. So that's one of the things that we can do as a corporate counsel. Considering all these factors, I mean, what we believe is that about 90% of the disputes, corporate disputes, could be settled at an early stage if it could be resolved through negotiation, whether it be formal negotiation or informal negotiations. I will talk of an experience I had in a company that I worked for previously. I believe Mr. Fernando would also recall this matter. The company received a massive claim exceeding 600 million arising out of a contract project. And when the company received the claim, we didn't have in-house expertise to respond to these specific construction-related claims that were made. So we recommended to the board that we retain the services of Mr. Fernando, who we found had extensive negotiation experience, especially in relation to the construction contracts. On his advice, we were able to uncover sufficient information and documentation that enabled us to negotiate a settlement which reduced the claim to less than 80 million before the dispute even reached the arbitration stage. This was done through extensive discussion and negotiation based on the information and the documentation that we discovered in the contract documentation. Thereafter, what we did was, with the learnings that we gained from that experience, we became more proactive. And when the next construction contract came around, we retained Mr. Fernando to advise us at the drafting stage of the contract itself. With the concurrence of the management, we got involved in the initial stages of the project and participated in discussions with architects, suppliers, contractors, and we were able to identify possible risk areas where disputes could arise. And we negotiated hard and provided for those risks to be covered to the maximum extent possible in the contract documentation itself. As an additional step, we also advised the business of the need to develop internal processes to ensure that the contract was managed well by the operations team, which could then prevent a dispute arising due to the mismanagement of the contract. So much so that I believe to date, as far as I'm aware, that particular construction contract, which was a multi-billion rupee construction contract, has not seen any major claims being made against it. So this would be a classic example of how we are able to advocate the process of negotiation as a means of entering into a contract. Therefore, when a contract is being drafted or negotiated, we must be aware that as corporate counsel, it's not only about negotiating the most effective dispute resolution clause for the contract, but it is also about negotiating the contract in such a way that you limit your liabilities and reduce your risks arising out of the contract to the maximum level possible at the drafting stage itself. For instance, in a recent contract that I was negotiating with a foreign company, having considered the risks that could arise out of the obligations set out in the contract, after many rounds of discussions with the other party and with the internal management team as well, we were able to reduce the exposure of the contract, exposure of the company to a level where both parties were comfortable with. And the contract was negotiated in a way that if a dispute were to arise out of specific areas in the contract, the parties were able to draw on the specific relief that was built into the contract at different levels without calling into dispute the entire contract. So I believe I've taken up my time in this segment, but in the next one, what I would attempt to do is to give a few more examples as to how, as corporate counsel, we can use the prevention of disputes or as the early management of disputes as an effective form of dispute resolution, and how the company can avoid the frustrations that come with pursuing litigation as a dispute resolution mechanism as a result. Over to you, Natasha. Thank you.
Thank you, Dulanga, for providing us with the knowledge on the practical use of dispute resolution in the corporate world. Before you go, we have a question from the audience. Prabha wants to know, for entering international arbitration matters, what kind of opportunities a lawyer has as a beginner, and is there any specific pathway to it? I think Mr. Fernando could also comment on it, since both have good experience in the corporate world. So Dulanga, first, if you may provide your insight on this comment. Or
I would rather have Mr. Fernando speak on that subject. Mr. Fernando, if you could, please.
Yeah, I think, international, I think also, if Justice Jasanta Kodagod also handled a number of arbitration when he was in the department, all I can say is it's a very sexy area, international arbitration. So when you say you want to get into international arbitration, first thing is, I think you need to get retained. So how you get retained is on the usual criteria, is that the client has sufficient confidence, or you're known that you need to, that they will retain your services. But having said that, don't wait until that happens. If you have an interest in international arbitration, I think there are lots of opportunities to develop your capacity as an international arbitrator or a service provider in the international arbitration arena, both in terms of substantial legal knowledge as well as procedural moves that you do on arbitration. So there are specialized courses, specialized master's degrees that come up. So there are lots of avenues available to you. But from a small place like Sri Lanka, to get into an international arbitration, unless a Sri Lankan client retains you, it's rather challenging. In Sri Lanka, there are few lawyers who have sort of quote unquote captured the international arbitration market. Maybe you could work with them. I believe that if you can demonstrate sufficient level of maturity and skill to your client, they'll be happy to take you. But the international arbitration is very different to what we do in Sri Lanka. So although the principles are the same, the way they understand international arbitration is very different to the way we understand international arbitration. So you need a different skill set, a different perspective, different ability to manage your case. It's very quick, short period of time, voluminous material. You should have the capacity both in yourself and in the chamber that you're with to do that and then take it forward from there. I hope I answered that question sufficiently.
And following up on Mr. Harsha Fernando's input, I would think a very important and extremely useful starting point would be to study both commercial arbitration as well as international arbitration, which are like two sides of the coin, possibly at master's level. So if you can aspire to secure a specialization in very broadly dispute resolution, specializing in commercial and international arbitration, by the time you come back, well, you don't even have to go out. There are means of specializing in this area while remaining in Sri Lanka. So you specialize at the master's level. And I think Mr. Fernando did come out with a very important point. And that is to start your career as a junior to an experienced, eminent, senior counsel. Particularly if you have good communication skills, if you show a genuine interest, if you have a disciplined personality with long-term goals, and if you have the requisite subject knowledge. I'm confident that any senior, a good chamber would welcome you. And as in all other subspecializations in law, the most conducive way forward is to join a chamber and gradually move up the ladder. If you indeed, Mr. Fernando said that it's a very lucrative specialized market being handled at the very top by a few. If you look at all their careers, they have come up that way. They have spent laborious years and possibly 2.5 decades as a junior and gradually gone up the ladder. And now they are strong enough to lead their respective chambers and handle these assignments, which are highly specialized assignments by themselves. Over to you, Natasha.
Thank you, sir, for your insights. Very sorry. I would now like to move on to the second round of discussions. The main objective of this round is look into the practical use and appropriateness of dispute resolution mechanisms for different forms of disputes. To start the second round, I would like to invite Mr. Harsha Fernando to speak on the topic of appropriateness of dispute resolution. Over to you, Mr. Fernando.
Thank you. I think I'll take forward from where Dulanga left off. She gave you a sort of very broad examples of what happens. And if you can recall where Justice Kodagoda gave you the different types of dispute resolution mechanism available, sort of the comprehensive list, I'll just share with you a framework that will help you to superimpose the two. I wonder whether you can see my screen.
Yep.
So this is what I want to say. You see, try this. When a client comes to you with a dispute, You just ask him, okay, you got a problem with your shareholder, you got a problem with your supplier. Do you want to solve that problem using this book, which is a civil procedure code, which is the due process, or do you want to use a different process? That's a simple question we need to ask. So if the nature of the agreement between the parties, now Mr. Tulanga gave a number of different examples of natures of agreements, depending on the subject matter, depending on where the parties are resident, number of criteria that comes into that discussion. If you want to have control over the procedure, so I try to bring it under two criteria: control over procedure and the control over outcome. Now, if you go to court, you have very little control over both, because the civil procedure code or whatever the procedure code that is applicable will decide on the procedure. You have no say over it. And the judgment is at the absolute discretion of the judge. You have no say over it. Once it's given, you accept it. End of story. On the other hand, if you want to have a control of outcome where you retain the service of a skilled communicator, Justice Kodagoda emphasized the importance of communication, which we also call the lifeblood of conflict management. Somebody who can speak to both the sides, not for a side, but speak to both the sides. In a mediation process, and it's formally done now, you actually enter into agreements with the disputants before you initiate the mediation, and you become a mediator. You have to give conflict of interest statements into the whole thing. The good thing about the mediation process is the mediator will have some degree of control over the procedure. He will decide who will speak first, what amount of information you should come, what things needs to be done to sort of break the ice, all that he will decide. But at the end of the day, if any of the parties are unhappy with the final outcome, you can always say, sorry, I'm not accepting this. You can walk away. So you have a high level of control over the outcome. But the procedure, you may give up some control to the mediator. On the other hand, if you go for the arbitration option, then you are at liberty to decide the procedure. You can use a procedure that is offered by different mediation centers, or you can even invent your own procedure. You can even say, okay, we will use this center, but we will decide on the procedure. Even if you decide on the procedure at the beginning of the arbitration, the arbitrators and the two parties can agree on a different procedure depending on the situation of the situation. So there you have a high level of outcome or control over the procedure. But once the arbitral award is given, it's no different to a judgment. You have to abide by it. So you have very little control over the outcome. Basically what you're doing is you are putting your problem to a third party and letting the third party decide. Of course, you can decide on the procedure before you get to that stage. So some of the things that I sort of personally recommend is where you balance both, where you have control over procedure and control over outcome, and we suggest the negotiation option. Now the issue is, in an average dispute settlement clause in most agreements, you don't at least have these 4 options. Justice Kodagoda referred to a few more. Contractual adjudication, conciliation. Conciliation, I don't know, sir, how you would define it, but my definition is where it's a mediation, but the mediator has technical skills, and therefore you conciliate the dispute better. I mean, that's one because there are multiple definitions, but that's what I would sort of look at it. Now, if you take, I think Zulanga referred to construction contracts. Now, construction is a field where you get disputes every day. Either you say the quality was not good or time extension, all kinds of disputes. So if you are to go to court and go through the processes of interim reliefs, injunctions, all kinds of things, the contract will never get completed. So therefore, the parties have invented a mechanism where they try to keep the conflict also within the whole arrangement. Sometimes when we do major contracts like roads contracts, I work with the ADB and we do large scale contracts we fund. Sometimes we have a permanent dispute settlement system inbuilt into the contract. That I believe is what Justice Kodagoda referred to as contractual adjudication. And there we have stages which Zulanga referred to, where we say, unless you do this, and do this, you can't go to the next phase. So we start from notice. We start from notice. You have to give notice and give adequate time to respond to the issue that the notice has given rise to. Then we go to the next stage. Finally, we come to a stage, something like arbitration. Now, why is this important? And this is what I want to show you. You see, normally, if you select mediation or negotiation, you really don't have an outcome in mind. You go with the mindset of saying, okay, we got a problem. Let's have a chat with the other side and see what we can do. And if you really get a skilled mediator, or if you're really good in yourself as a good negotiator, the dynamic is where the parties will, though they don't attack each other, they will say, okay, we got a problem, maybe profit sharing, maybe delays in supplies, whatever, we got a problem. Let's get together, put our heads together and try to find a way to attack this problem in a way that's good for both of us. So when you do that, the dynamic it creates is that you want to make the cake bigger before you cut it. So even if you get a relatively smaller piece, you're still okay because you're getting more cake. You might get a smaller piece relative to the other side, but still in the ultimate analysis, you're getting more cake. So the whole dynamic is create value, make the value bigger so that there'll be enough to divide. Sometimes if a supplier, for example, a supplier has delayed and you want to do go for a penalty clause under the agreement. But you might negotiate and say, look, okay, I'm not going for the penalty clause, but there is another 5-year contract that I want to give you. In that contract, you will give me a small discount so that I can recover this loss. Completely outside of this contract. But you take a long-term view of the relationship, long-term view of the value that both parties can create, and you make the pie bigger, you make the cake bigger. But if you go for arbitration or courts, you think differently. I'm sure all of you will agree with me. When we draft papers to win. We draft papers to beat the other side. We are not drafting papers to share information. We are not drafting papers to ask them for their information and see whether we can make the cake bigger. We don't do that. So in a court procedure, we start from the other end and work backwards. Either it's either all or nothing is the only outcome you'll get from a court, unless a judge intervenes and sort of persuades the parties to settle. Otherwise, it's all or nothing. So when it's all or nothing, your every strategy you do is you design it to do it that way. That's why we have got a bad reputation as saying, don't trust us, lawyers cannot be trusted and all that. System is designed. But if you do the ultimate analysis, you will find people who have gone through litigation. Even if you win, you have lost. You may have won a particular award and got some money and compensation, but the long-term relationship, the cost to you in terms of man hours lost, your business reputations, you have probably washed a lot of dirty linen in courts in the form of examination in chief and cross-examination. You ask a question in a very disparaging me from the opposing side witness, that witness is not going to get angry with you. He's going to get angry with your client. And we forget that because we have the immunity of a lawyer in court proceeding. And we actually kill whatever the possibility for those two parties to come to a fight. So what I'm suggesting is, don't forget this part. This one, sorry. This is the issue. See, you must get together and attack the problem so you find a solution. Right? It is from there that you get into what we call the enlightened way of dealing with disputes. So, to give you an example, if you, Justice Kodagar mentioned about conflicts. Do you see the great thing about it is if you change your attitude a little bit, in every conflict you see opportunities. Conflict is they want what we want, the way you see it. But the opportunity in that is we can actually find out what they need. I don't want to go through this list. You have it on the screen. But this demonstrates one thing. You see the one on the left-hand column under the subheading conflicts. This is the way it gets formed, and this is the way it remains under the Civil Procedure Code. Once you do the issues and all that, this is it. There is no way. Even the pleadings go into the background once you do the issues. Issues are absolutely contentious. There is no way in our procedural laws, under the Supreme Court regulations, of course, there is a small clause for mediation. There is no way for opportunities to create value. So understand that, deal with this at the point of putting in your dispute settlement clauses and mechanisms in your contracts. So if you're going to do that, what should your role be as a lawyer? So these are a number of roles that you can do. You can be a negotiator. You can negotiate on behalf of the client. Or you can be an enabler where you create an enabling environment for the two clients to sort out the dispute. You can mediate. Then you can't take one side, but you become the enabler for the both sides to come together or conciliate. You can be a problem solver, the elegant solutions. You can be the consolidator, and expert. But at the end of the day, what everybody is looking for is no longer that trial law is I think criminal law, it's still there. But in civil law, that being that great trial lawyer is good for you, but bad for your client. I think what everybody is now looking for is a high quality, user-friendly legal services provider who understands the difference between commercial decisions and legal rules to create value. Justice Kodagoda emphasized the word justice according to law. He emphasized that phrase. And that's what he's saying, because I think, so in other words, what you're saying is the court is hamstrung, for want of a better word, because of procedural laws. So in places like US, you have court-linked mediation or court-linked arbitration, more than arbitration, mediation. That is there. Maybe we can bring it in somewhere down the line in our systems also. But what Justice Kodagoda mentioned there is the inherent limitations that the court has. But if you link up that comment with what Dulanga said, there are certain disputes you have to go to court. I understand. But not for everything. And I think the disputes that you need to go to court is very few if you have an enlightened approach to dispute settlement. Over to you, Natasha.
Thank you, Mr. Fernando. On that same topic, since we spoke about the court mechanisms as opposed to other dispute resolution mechanisms, I would like to invite Justice Kodagoda to provide us with some insight on whether using other dispute resolutionary tools could actually help enhance the efficacy of court, or whether it actually dilutes the efficacy of court, especially in terms of what types of conflicts should we actually keep outside of court, and what types of conflicts should we bring to court. Sir, if you may.
Thank you, Natasha. Ladies and gentlemen, I think, as I said during the first round, as repeated by Mr. Harsha Fernando just a few minutes ago, it is, I think, very important to know that by engaging in litigation and inviting court to adjudicate a dispute, what is it that you're asking the court to do? You're asking the court to decide on the dispute and not necessarily resolve the dispute. These are two different things. Decide on the issues presented to court for resolution in terms of the law. So it is indeed justice according to law, and hopefully it will result in a resolution of the more important out of the several issues confronted by the litigants. So, as I said right at the very beginning, even the party that technically won the case may not have received a degree of satisfaction he is in fact content with. So I would think when you look at this spectrum of dispute resolution mechanisms, I would personally think unless there is a compelling need to obtain interim measures or interim relief, as we generally use interim relief, unless you're convinced that the other party is not acting in good faith and is not desirous of any resolution of the dispute, that is absolutely dishonest or extremely arrogant and has fixated views. Some people are extremely arrogant, selfish, and have fixated views. I don't think you should go in for litigation and invite a court of law to adjudicate. I'm of course conscious that there are certain disputes that can be resolved only through litigation. Take, for example, very serious crime. Take, for example, a serious decision taken by the state that has an impact on your rights, and the state is not amenable to change that decision. In those instances, indeed, the only efficacious process would be litigation. And as Mr. Fernando said, keep it as the last resort. Unless due to the changing landscape, you are compelled to go into court or rather rush to court and obtain interim relief in order to freeze the changing, rapidly changing landscape. I think as lawyers, you need to start by looking at negotiations as the first option, particularly if time is in your side. Negotiations through informal means where the disputants themselves can directly meet, communicate, and try to resolve the issue amicably. Amicably is the key term for negotiations. Amicable settlement of the dispute, where the disputants will have total control over the process as well as the outcome. Now, a theorist would say that negotiation is highly desirable because you come back with a win-win solution. I might not necessarily agree that negotiations would always result in a win-win solution. I think through negotiations, what you can reasonably expect is optimal satisfaction of interest. Optimal satisfaction of interest as opposed to absolute satisfaction of your interests. And if so, the starting point would be to venture and consider whether the parties can directly meet and try to amicably resolve the dispute. And we give this sophisticated term negotiation for an amicable settlement. The second way would be for the two parties to be represented by professional negotiators, either in their presence or in their absence. So you meet formally as a representative of your litigant, and it will be you who will go. You're looking at a professional assignment, which makes it very attractive. Both sides will be represented by professional negotiators, and we as lawyers, I think, are ideally suited to be professional negotiators, and you formally engage in discussion with what? With one objective, and that being to optimally satisfy the interest of your respective clients. In order to be successful in this regard, you must have, and I underscore this term, you must have the skill to separate the position your client and the position his opponent takes vis-a-vis the underlying interest that propels your party to take up that position. Take, for example, an issue relating to custody of children between estranged matrimonial partners. both parties would want total custody over the intervening children. So the parties would have to ask, or you as their legal representative would have to encourage your client to identify why he wants total custody over the child. Similarly, the other party would also have to ask that question. It's an introspective questioning of why they want custody over the child. Now that enables you to separate the position. The position is at loggerheads. Both parties want total custody over the child. So the position is at conflict with each other. But why the husband wants custody over the child may be to be in a position to meet the child and play with the child during weekends. Why the mother wants custody over the child may be because she wants to nurture the child and provide physical protection for the child, and therefore she wants the child in her precincts, in her house, so to say. So you will then see through this example that the position that the parties take would have to be distinguished with the interest or the underlying objectives they have. And through a successful negotiation, you might be able to marry the two interests. The underlying interests and the underlying objectives may not necessarily be at loggerheads, though the overtly visible positions of the two parties are at loggerheads. So it's a case of optimally satisfying, not fully satisfying, nor not satisfying at all, but optimally satisfying the interests of the two parties. So we really don't have time to go through mediation and conciliation to this extent, but I would just take one more minute and say that mediation is a different process because you find here the arrival of a third party, and that is the mediator. It is essentially still a negotiation with the participation of a third party who is impartial, who is unbiased, and who is neutral. His intervention is aimed at helping the two disputants to understand their respective cases and each other's cases. Why are they at dispute with each other? He also supports the parties to develop possible solutions. So maybe there will be a bag full of solutions with varying degrees of attractiveness. And then he will encourage the parties to pick and agree on one of those possible solutions to the problem. That is what a mediator does. Now, conciliation is a slightly evolved process from mediation. The only difference is it starts off as a mediation, it remains a mediation, but at the end of the process, if the parties left to themselves do not agree on a possible solution to the dispute, the conciliator, now the mediator becomes a conciliator, and that is why I said it's an evolved process. The conciliator presents to the parties his opinion on the matter. In his opinion, what ought to be the possible terms of settlement. So it is only his recommendation. It is non-binding. Parties can either agree or not agree to accept it. It's a non-binding process and very important process. So today we can only speak to this lens, but it would be very interesting to look at negotiations, mediation and conciliation in greater detail whenever we get the time. Over to you, Natasha.
Thank you, sir. I would now like to invite Ms. Lulanga, if you have any practical experience as to how you can use these tools in the corporate world and how you differentiate each tool based on what type of conflict you're facing. If you could provide us a very brief practical example of one of those situations so the audience is also able to see the real life application, it would be very much appreciated. Over to you, Lulanga.
Thank you, Natasha. So it is because of the very reasons that both Justice Kodagore and Mr. Fernando spoke of how parties can lose out by pursuing confrontational dispute resolution mechanisms, that we as corporate lawyers are expected to play an additional role of helping our companies find solutions that will not put them in a confrontational position. And so we, in our corporate role, effectively advocate for the prevention of disputes or the early management of disputes as an effective dispute resolution method. So whilst still believing in the various alternate dispute resolution mechanisms that are available to us, we can add value to our companies if we can prevent a dispute from happening in the first place, or from a dispute escalating to a level where the parties will be compelled to enforce the mechanism that is built into the contract. So early management disputes as an effective form of dispute resolution is an important tool for in-house counsel. For instance, in a procurement contract of either goods or services, if your company as the buyer is obligated to pay a sizable advance payment at the commencement of the contract before any part of the goods or services are delivered, and the other party is unwilling to reduce that quantum, you can negotiate, or you can advise your business team to negotiate to either build in a staggered payment option for the remainder of the fee, supported by specific milestones to be monitored by the relevant manager of the contract, or you can negotiate for the seller to provide you with a performance bond or a bank guarantee to secure the advance payment, as well as that would also encourage the supplier to perform the remainder of the contract as well. Another instance when advocating for the practice of dispute resolution, dispute avoidance as a resolution process. One example I can use is in relation to employment contracts. Most employment contracts would involve an inherent mechanism that allows for the disputes to be escalated to the Commissioner of Labor for resolution. However, from a corporate perspective, it would be in the company's interest for the in-house counsel to find a mechanism to resolve the dispute at company level without having third parties getting involved or without allowing the dispute to escalate further. When it comes to employment contracts, although the HR department may look at the issue from a human resource angle, we as in-house counsel are expected to have a specific skill set to understand what type of disputes can arise beforehand and to advise the company on how to mitigate that risk. Either it could be through contractual provisions itself, or it could be even through the adaptation and enforcement of internal policies. Another important thing you can do as a corporate counsel to prevent disputes arising out of contracts is to train and educate your business teams on the importance of managing the contracts in the first place. Many companies tend to believe that managing the contract is the responsibility of the legal department. However, I don't believe that. When I say managing the contract, what I mean is monitoring the performance of the contract. In short, how the contract owner should ensure that his or her team tracks the performance of the counterparty obligations, as well as, more importantly, tracks the performance of the company's own obligations that the company has to fulfill in terms of the contract. because you don't want to be in a situation where the dispute has arisen due to a fault on the part of your company. So monitoring the contract is an important aspect, and most companies don't have that practice. So I believe training your management teams would be a first step. There is also writing of letters of demand. Some contract owner, sometimes a contract owner will come to you as the in-house counsel and ask you to write a letter of demand to the other party, simply because the other party may not have performed some part of the contract in the first instance. Before we take steps to start writing the letter, as in-house counsel, we would explain to the management the repercussions of sending such a letter in the first instance, and also the repercussions of not following up with the actions warned of in the letter. Most of the times companies don't realize that a letter of demand is actually a precursor to a court case. They may not, there might not be a point in writing the letter of demand if you're not going to follow it through, because then you lose credibility with the other party if you don't follow through. So what we can do then is to try to talk to them out of writing the letter in the first instance and suggest a negotiation mechanism where we can assist the team to come to a negotiated settlement that can help the company mitigate the loss to the best extent possible, rather than pile on more costs in terms of legal fees and wasted man-hour costs. I don't believe any corporate would prefer litigation, but more often than not, we find ourselves having to file cases or having to respond to cases filed against us. We are aware that litigation comes with many frustrations, such as delays due to bottlenecks in procedures or backlog of cases. Also, the extremely slow enforcement mechanism and the long drawn out time-consuming appellate procedures. And of course, more relevantly for corporates, the costs involved, the high costs involved, both in time and in money. These delays would favor parties who don't really intend for the dispute to be resolved. Parties who go into the dispute, as Justice Kodagoda and has Mr. Harsh Fernando said, to fight out and win. So there are parties who may benefit from the delays. Also frustrating is the powerlessness to predict the outcome of the case. There is no possibility to predict, because there are times when our clients ask us, what do you think? Would we win if we file the case? And there's no way we can give them that answer. But there is also a possibility that the ultimate judgment may not necessarily address or redress the issue that we were seeking to adjudicate in the first place. Then at the end of the day, even if we win, we feel as if we don't really feel that we have won the case. So I believe, as a corporate counsel, acting in the best interest of our clients, who are the companies that we work for, we must advocate to make use of the various alternate dispute resolution mechanisms available to not only resolve the dispute, but as much as possible to prevent the dispute from arising or escalating before recommending litigation or even arbitration as an option. So we must make use of the entire spectrum of alternate the dispute resolutions that are available there, and choose the most appropriate, or even a couple of the most appropriate and least expensive means of dispute resolution, and keep litigation only as the last option. So that's all I have to say for today on that matter.
Thank you, Dulanga. Unfortunately, time is running out, so I would like to quickly move on to the question and answer session. We have got a few questions, and I also would like to invite all the people in the audience, ladies and gentlemen, to please provide some good questions in order for our panelists, the very distinguished panelists. We only get this little time and very little opportunity to actually ask any questions from them. So please provide your questions to me so I could ask them, and we can somehow, within this very little time, try and get some very good insight from these three panelists. So the first question that we have would be, for the purpose of judicial adjudication, the purpose of judicial adjudication is to achieve just results, and negotiating is focused on achieving individual interests. Is there a method to harmonize these two, especially during pandemic circumstances where access to judicial adjudication becomes limited? I think Justice Kodagoda, you may be the most appropriate to answer this question.
We do most of the time try our level best to resolve the dispute, not only in terms of the law. Of course, resolving it in terms of the law is our paramount duty, and we consider that to be an obligation on the part of a judge to resolve the dispute in terms of the law. Sometimes the applicable law is of such nature that there can be a slight gap between deciding a case in terms of the strict sense of the law and deciding a case in terms of justice, which is somewhat of a vague, extremely wide concept, as well as deciding a case in terms of principles of equity. Unless our jurisdiction very specifically provides us to apply principles of justice and equity, we must necessarily decide the case in terms of the strict sense of the law. And this is why at times, even the party that technically wins the case may not feel that he has won. He might go back home without full satisfaction of his expectations. Whenever we feel that there is a gap between what the law demands us to do vis-a-vis what justice and equity would warrant us to do, we try to hold the scales in the most delicate manner so that we strive to ensure that the decision is technically lawful, but is just and equitable as well. So it is very challenging at times. It is very challenging. And indeed, you have raised a pertinent issue, the very unique circumstances arising out of the current pandemic. Such situations can have an impact on the performance of contractual obligations. But then again, we now have very recently the latest law in place referred to as the COVID-19 Special Provisions Act, which was certified by the Honorable Speaker less than a week ago, a few days ago, which was vetted incidentally by the Supreme Court, and the Supreme Court in its determination explained to Parliament the manner in which certain inconsistencies with constitutional norms ought to be redressed, and at the committee stage during the parliamentary debate, the original bill was amended so as to bring it in conformity with the determination of the Supreme Court. And that, of course, provides for this very same issue as to how principles such as common law principles such as force majeure could get addressed by a court of law if an application is made to court in terms of the special provisions law. I would think in view of the very limited time we have, I should not go beyond this because we are really short of time at this moment.
So if I may also add a small comment to what you said, I sometimes take the view that if you're seeking justice, negotiation may not be the answer. You need to go to court. If you're seeking justice, because justice entails a lot of things. So if justice is what you're seeking, I think the courts, which is strong powers of enforcement, where you get to say your views, might be the answer. But answering the second
one, the other side of it is justice is a very vague term, and people view justice differently. What is justice to one party may not in fact be justice to the other party. Whereas the law, and particularly the written law, is so apparent on the face of things, so to say, so that deciding a case in terms of the law might be a more definitive way forward.
That is the reason, so actually we change our submission depending on the bench. So having said that, so also think answering the second part about the on COVID situation, already the courts have developed the jurisprudence on dealing with pandemic and force majeure issues. So I think whoever the person has asked this question says where judicial adjudication becomes limited. The challenge that I personally give my client who is drafting a contract is assume there is no court. Assume that this will never go to court. Now figure out a way to sort out your dispute. I think that's a good assumption. And actually, I think the COVID has its own silver lining, the dark cloud. One is the courts are now going online and there is a very different kind of efficiency being built into the court procedures. But also clients are looking at ways of resolving disputes that are not necessarily court-based, which I think is a great inflection point for alternate dispute resolution. And somebody else also has asked very quickly whether under the pre-trial procedure there is room. If you look at section 142DG, 142D for David, G, there is a section where the judge is empowered to motivate the parties to come to a settlement. So it is there, but I think so you will also agree that you need a different skill set to be a mediator. The judge is a very good mediator, provided that skill set is there. And you need a lot of maturity in terms of the shift between a mediator's mindset and an adjudicator's mindset. So I think these are areas that hopefully the Judicial Services Commission, the Judges Training Institute will take into account, and then start developing the capacities of judges to play this dual role. In fact, many years ago, we did a session for the labor tribunal presidents on their use of mediation techniques to resolve disputes, because that's a tribunal, essentially not a court. And one of the things that one of the presidents recommended was, if one LTA president has attempted mediation, the case or the trial should not be heard by that LTA president, and it should be heard by completely somebody else. So that reflects the challenge they were facing to change the mindset from seeing a settlement and then take a dispassionate view. So I think the question there demonstrates a good opportunity for litigants and lawyers to provide services in a more meaningful and a more efficient manner.
Thank you, Mr. Fernando. Thank you, Justice Kodagoda. There is one more question I would like to actually pose to Ms. Dulanga. The question is, in real life, there is a significant impact of gender of the parties in resolving disputes. Sometimes this may create an unfair benefit to a party. How do you overcome such situations and bring the parties to a level playing field?
Well, to answer that question, in my experience, I would like to think that I have not come across a situation like that, because as long as you speak to the facts, as long as you are conversant with the facts of the dispute that you're discussing, or the facts of the contract that you're negotiating, and you're aware of what your rights are, then there shouldn't be a question of gender being involved. Have I come across situations where there have been attempts to, well, I won't use the word override, but to question every fact spoken of by, I can speak of only my experience, or by me. Well, there have been, but all of those instances have always ended up with, that party accepting the position that we have taken up, simply because we speak to the facts. And, if you're very straightforward and you speak to the facts, that shouldn't be an issue. But That does not mean I don't want to take it away from anyone that that problem might prevail, but the advice I can give you is be sure of yourself, be sure of your facts, be sure of what you are discussing, what you're talking about, and what you are negotiating for. And I don't believe that there will be an issue.
Thank you, Dilaka. I'm sorry, my apologies for interrupting, but unfortunately, we have a lot of questions that have been asked even on YouTube. This one question I think is very important. This is to Justice Kodavara. When one party simply fails to respond or communicate in an instance where both parties are attempting to resolve a dispute, will court consider the same in awarding damages and no cost to the other party due to being compelled to resort to litigation?
The psyche pertaining to responding to alternate means of dispute resolution is generally not taken into consideration unless it becomes a part of formalized dispute resolution. Take for example, situations where the dispute resolution clause requires an attempt at resolving the dispute through negotiation as a precondition to be satisfied in order to go in for litigation/adjudication. Now, in such instances, if the plaintiff can show that the defendant arbitrarily, without any valid reason, did not respond to the invitation extended to that party to at least attempt to resolve the dispute through amicable means, that can be a factor to be taken into consideration when awarding costs. So a good faith approach in terms of the law to initially resolve the dispute through either negotiation, mediation, or conciliation, I think is necessary and a useful starting point, unless, as I said at the very outset, that the landscape is changing at such a rapid pace. The innocent party requires a mechanism to freeze the status quo, and that is through obtaining interim relief. Then indeed, you will be justified in rushing to court as your first port of call.
So,
Thank you.
if I may add, sir, in the UK jurisdiction, the amendments are such that during a trial, a party can make an offer for settlement, which is not shown to the judge. But understanding is that at the end of the judgment, all those will be considered by the judge in awarding costs. So if the judge feels that a genuine attempt has been made and the other party has not responded in good faith, the judge will take that into account in doing it. So what they have done is they have brought
so
in
that's provided in the rules over there.
That's provided in the rules. So what they're doing is they're bringing a systemic incentive for the parties to move towards the ADR even while the case is pending.
So maybe, Harsha, that is a possible mechanism we should very seriously study with great interest, to be introduced locally as well, isn't it?
Actually, yes, I think the recommendations are being made. So I thought I'll just share that with you, because at the end of the day, the different systems that were shared in this presentation, we must not forget that those are processes. All these are dispute settlement mechanism processes. And the use of the process, it's like the railway track. The railway track destination is the train, but the track decides where you go. So these are processes, and the processes will decide the outcome. So we must never forget the dynamics, the positive and the negatives of each different process.
Thank you. Thank you, Justice Kodavara. Unfortunately, our time has come to an end. And I want to take this opportunity to thank the panelists for taking their time today to provide us with valuable insight into the options of dispute resolution. I would also like to thank all the participants for engaging in discussion and making it interesting and enjoyable to the panelists, even though we have very little time. And last but not least, I would also like to take this opportunity to thank the BASL Professional Career Development of Women's Lawyers Committee for providing us with this invaluable opportunity to be a part of this webinar to learn from this distinguished panelists. I would now like to hand over this discussion.
Thank you, Ms. Natasha Noordi. On behalf of the Bar Association of Sri Lanka, the Professional and Career Development of Women Lawyers Committee, and the Seminars Committee, I would like to thank Honorable Justice Yasantha Kodagoda, President's Counsel, Mr. Harsha Fernando, Attorney at Law, Ms. Dulanga Pereira Weideman, Attorney at Law, and Ms. Natasha Noordin, Attorney at Law, for this very informative and valuable session on the topic Options for Dispute Resolution, or rather, as Mr. Fernando contextualized, Options for Dispute Management. I would also like to thank all of you who joined us through Zoom and YouTube, and for your questions that have made this webinar an interesting one. Thank you, everyone, and do join us next week on Sunday at 7 p.m. for the next webinar in this series. Stay safe and good night.
Good night. Good night.
Thank you. Good night.